Twining once remarked in my hearing, in fact, at the inaugural meeting of the UK Association for Legal and Social Philosophy, that he was attempting, when somebody asked him a question, what's your position? He said, my position is that of somebody who tries to present a moving target. But one of the marks of a successful workshop is, of course, that as it wears on, you think somewhat new thoughts, and the paper, just as you wrote it, doesn't seem any longer quite the thing if it ever was. So with that in mind, I've been rethinking a little, not the basic ideas in the papers, which, as many of you will know, simple and obvious, but how to locate them in the context of the conversation at this enormously successful workshop, which I, for one, am so grateful to have been asked to take part in. The framework of what I'm writing is this so-called institutional theory of law that Nikki was kind enough to mention in her talk yesterday evening, and as others of you know from another recent workshop, the phrase that it homes in on is the idea of institutional normative order. This is an attempt to name the genus of which state law is one species. I think myself that jurisprudence has been rather stunted or crippled over the years by just taking the state, as it were, for granted, assuming that everybody is parceled out into sovereign states, and law is paradigmatically only or mainly just what these things have. This has had the effect, interestingly, that it's taken us about 30 years after the UK joined the European Community for those of us in the jurisprudence community to start to ask ourselves seriously about what's going on here. We have, as it were, been living in the middle of a black hole or a supernova or something. Everything is changing about us, and we've clung to our old analysis of state law as cheerfully as we could, without really thinking, well, don't we have to acknowledge that kind of plurality of legal orders now, for those of us who live in Western Europe anyway? Though Peter's remark yesterday about the law takers and lawmakers reminds us just how much this kind of plurality of surrounding legal orders affects even ostensibly undiminished sovereign states like Australia. So to start thinking that is to think we must be capable of a pluralistic view of law, if only just to comprehend the not sovereign European Union of now not fully sovereign states, each with a legal order, the legal orders in interaction, but not with mutual identity. I think there's a kind of Kelsenian response to that, as various of you know. But we're in an interesting world, a world in which we can think pluralistic thoughts, and that I think also makes easier coming to better terms with some of these other issues which concern us, like how do we deal with the legal order or the social, do we deal as legal order with the social order of peoples who do not live in states, in territorial states, which is one of the key issues here now. So, looking at my rough notes here, institutional theory, pluralism thereby, sovereignty and post-sovereignty. We live in Western Europe, those of us who live there, in post-sovereign states. This might be only a passing phase. Maybe the euro won't work, maybe the money system will break down, and we'll go back to being sovereign states, probably at war, awful thought. Or maybe it will work, and maybe this is just a passing phase, and we'll end up with a sovereign federal union there, just as you have here or in the United States. But I hope not. I think not going that way would be to do with having discovered that we could imagine a different way to be, a way in which you put together legal orders in a pluralistic way and get beyond sovereignty. Now that might be a good thing, or it might be a bad one. It might be helpful to human interaction, but it might, and I think some part of Tom's thinking would suggest this, it might deprive democracy of its cutting edge, because it would be harder and harder to say who's in charge here and make them democratically answerable. But under post-state skepticism, personally, I think that the sovereign state, the imperial state of the 19th century was an obviously interesting phase of human history, but it had really surely as much of potentiality for evil as for good in it. And if we could find something beyond that, it would be a good thing. Now, one vision of legal positivism that came out in the course of the discussions here, not ethical positivism, but old-style positivism, hard positivism, it says that the world just has to be divided into sovereign entities, and these entities issue laws, and all that goes on is subject to that kind of law. That's different from the thesis that legal order is different from moral order. Now, I'm a positivist in the sense that I think legal order is different from moral order, and not a positivist in the sense of being a statist. And I think quite a lot of what positivism gets blamed for, it would be more proper to blame statism for, and I think that quite a lot of the feminist critique, in my judgment, comes under that rubric. But all this, and number 5 on the little sheet, all this suggests that we can understand normative order. And can we? The strategy ought to be to think of examples which are reasonably far from anything that we would ordinarily consider positive law. And my current favourite example is standing in a queue. I was walking along from Liversidge Court the other morning, and I saw a group of people standing strung out beside a post. And I immediately inferred that this was a bus stop, because you wouldn't get people standing just like that on a cold morning anywhere unless there was some account of it. And I intuitively took the account to be the bus queue. If I try to get a bus into Canberra in due course, I may prove to have been wrong in my inference and will be disappointed and even colder. But queuing is a tremendously pervasive thing, isn't it? I go in for the coffee, and already an informal line forms towards the coffee urn. Now, there's no enactment, no positive norm about this, not even Tom, control freak though he may sometimes appear to be, has ordained that we must stand in line for the coffee. We just do. Now, in this respect, queuing or telling the time, all these things, we all do it. And we all interpret each other as doing it. And each of us could, I guess, if you pause and think about it for a moment, you can formulate something that you might think is roughly the rule that you think you're following and think other people are following. If you come to a point of service where more than one person wants served, seek service in temporal order of arrival. Something like that, I don't know. But you think, well, that's not a very good formulation, and you come up with another. But the truth is that we manage to queue, even though none of us has probably formulated this thing articulately. And our languages and things are like that too, aren't they? We manage the semantic and syntactic rules of the language before we've written them down, if we ever do. And now that grammar is no longer taught, we've managed to speak without knowing the rules. Though increasingly few people can write. So we do have this, this is where I come in with Tom, both in the book and in the paper. We are aware of being able to coordinate with each other and interact in this kind of way because we have a common normative understanding, but it is not necessarily articulate, and it is not necessarily identical in terms. But that can change. I was very nearly seriously assaulted in a supermarket in Texas in February, actually just as I was writing this paper, at the fish counter of an excellent place called Central Markets in Austin, Texas. They've got one of these rolls of paper, and you pull out a number, and then the light above the thing comes on to numbers in sequence, and you go forward, an appropriate air of meekness when your number comes up and you get served. And I was in the process of getting my mahi, and the guy behind me said, "Hi, mister," he said, "you always cut in like this." I said, I was holding my number. Unfortunately, I was holding it upside down. They had called 66, and he thought I was 99. There are always problems of interpretation. Curate. On curate.
Wasn't attacking you in shop.
Right. So what you have there then is something different from just waiting in line for the coffee. Somebody has set up a system under which there are now articulated rules. You have to take a number out and you have to be served in order of the number. And there's an official in charge. There's the guy behind the counter who isn't going to serve you unless you come forward with the right number, except, of course, if you succeed in cutting in and breaking the norm, hold your 99 upside down, jump in fast before anybody notices. And that, of course, is the same at airline check-ins. Can't get booze in Sweden without going to the Systembolaget and having to get a number and wait for your turn. And if it's a Friday night, you're as well to go off for a coffee because there's many people ahead of you in the line that take your while to get there. So there you have a new thing, don't you? Because now there would be a possibility of an articulated answer to what's the rule here. Presumably the management of the shop has done or will sometime do, if it gets problematic, a writing down for their staff of what they have to do. For example, what do you do if you call out a number or a number comes up in order, there's a no-show, and you go on to the number, you go on to 69, because 68 didn't appear. Then 2 minutes later, 68 comes puffing up and says, "Hi, take me now." Now, do you say, no, your number is cancelled, you must go back to the beginning, take a new number out? Or do you say, sure, you're now at the head of the queue? Problem here, it's got to be solved. At least it would have to be solved if it was a recurring problem, and people get into fights and argumentation, or customers get angry and say, "I'll take my custom elsewhere unless you guys get this thing shaped up smarter." So now you have what I would call institutionalization. And the context of institutionalization is one in which you can make the norm more articulate. Somebody now says, whatever you understand, our rule is this, and they can write it down and they can publish it and set out a notice letting customers know what they have to do and how they have to be served. Now, as the 6699 just reminds us, even doing that doesn't make it absolutely all purposes clear. But as Tom and I both want to say, it makes it very substantially clearer. You haven't got rid of all the interactive indeterminacies of human mutual misunderstanding. Of course you haven't. But you have got a somewhat clearer arrangement, and an arrangement for making it yet clearer by the action of somebody in authority, who will say, right, I have to decide this. Campbell is ahead of McCormick, now just do it that way and you'll get served. And if we start fighting, say, well, neither of you will get served. And somebody else comes in. You know, the very effective way. And of course you can't get onto an aeroplane or get onto a London underground train or any of these things unless you do the queuing thing properly. You just can't get on. It becomes a part of these institutional facts, become hard facts in a kind of a way. They structure the way that the world is for us and the possibilities we have to do things. So, under number 6, normative order becomes institutional given 1 plus n tier systems, where the nth tier usually, or for reasons that are obvious, the nth tier is always going to be customary in some form. So we don't get rid of customs this way. You can't get rid of customs this way. But customs can create frameworks within which institutionalization can happen. This, I think, is the bit that you've always got to hang on to from Herbert Hart or from Kelsen in one of the readings of Kelsen. That normative order is dynamic, institutional order. It regulates its own creation. It is, in that sense, autopoietic. And the uses of this are, as various people have been pointing out, Jeremy, Tom, and others, determinative. It makes things clearer. It makes life simpler. You get on to the plane faster. And you get onto it more reliably, don't you? It can be effective, and it can be effective particularly in the interests of weaker people. I remember trying to get on board a bus in Florence with my youngest daughter who is a person of spirit, but just physically very small. And the way bus non-queues operate in Italy is a fearful sight to behold. And it's much easier if you're built like me than built like Sheena to get onto a bus. So that, you know, there's a very easily misunderstandable point here, protection of physically weaker feminism, question mark. I'm of course not in the game of suggesting that, you know, women are the weaker vessels and all that old stuff. What I'm saying is that the ethic of care that we were thinking about last night is an ethic that is better satisfied by arrangements which say, look, we'll all get on better if we all find a way of taking our turn and behave reasonably, rather than everybody insisting on some hard right. And when you get this kind of institutional order with the kind of determinacy, the relative determinacy that it produces, it does create circumstances where protection of less advantaged people, although they always remain less advantaged, it can to some extent be achieved. But of course, it's heteronymous. All these situations are situations in which, so to say, we confront the alien will. In a way, you come to a fence in the field. Now, you would not ordinarily wish to not go that direction, but this suggests you that there's a law of property here, and that if somebody's put up a fence, you shouldn't cross it, or you better be careful about what the particular local laws of trespass and so forth are. Or getting onto the bus, or buying your booze in Sweden, or whatever it might be, you have to organize your conduct according to patterns that aren't self-made, not by you. And that's true of us all. The price of institutional normative order is that we act, at least partly, heteronomously. Of course, we might, as autonomous agents, say, this is how I will it to be for me. There's always going to be an interaction between autonomy and heteronomy in our lives, as moral agents. But it's worth noticing that this pair of concepts applies in some important way here. And for some of us at least, the idea of morality as the kind of ultimate ground of judgment postulates a very serious kind of ontological autonomy. It's not your real moral judgment unless you sign up to it as you for yourself, because that's how the world, in your view, ought to be. The issue of whether law and morality are conceptually distinct seems to me to turn on just this point. If you have a kind of that somewhat Kantian vision of what morality essentially is, then it's going inevitably to be different from, although totally interactive with, the legal, in the sense of the institutional normative order. And I think that's an important feature of ethical positivism. Ethical positivism says, well, we can be autonomous, in a sense, as participants, co-participants in a democratic order, provided we then take as final the collective decision and demand that everybody thereafter knuckle under whether they would have voted for that one or not. That was David's point again of yesterday. Of course, there shouldn't be an absolute knuckling under. Exactly the survival of the autonomous agent within the heteronomous order guarantees that, or should guarantee it. But particularly the judges. Of course, we don't want judges who hang up their conscience as they take off their jackets and put on their robes. Of course, we don't want people who will never ask themselves, can I in conscience go forward with this that the law requires me to do? But we do want them, when they ask what does the law require me to do, to ask what it requires, not what they would like. And that is, I think, at the heart of Tom's argument. In this context, I always get irritated, and I feel I evinced irritation at an earlier period of this conference, when people talk about the law as autonomous. I think it's very, by your metaphors you shall know that. We should not take abstract entities like law or legal system and ascribe to it qualities that can only belong to conscious agency. Now, I don't think conscious agency is only possessed by humans as individuals. Of course, there's group agency as well. There are many, many things that you can't do as an individual, but that humans can do, like play a symphony or win a game or football. is not an agency. Law, of course, is managed by agencies. There are courts, there are agencies of state, there are legislatures. We can ask if these are autonomous, but I don't myself think it makes much sense to ask if law is autonomous, especially since in this terribly important way the real feature of law is the heteronomy which characterizes our life within the law. Of course, you can ask other important questions, like are law schools entitled to some kind of autonomy within the academy because they do run a separate discipline, or should we be rolled in with the social sciences, or whatever it might be? And these things passionately get argued about. And I think a lot of the discussion of some aspects of positivism and the autonomy of law, that some of the ones that Nicky was talking about last night, are to do with this issue, whether there is a body of knowledge, Wissenschaft, legal science, that we are the possessors of, that we hand on to a new generation, and we know something that other people don't know because we are experts in that. Is that picture of this possessed body of knowledge, hard fact knowledge, that, I think, has often been associated with positivism. Maybe it shouldn't be, but that does give rise to the kinds of protests that Nicky was referring to last night, I think. Well, normative audit, norm creation, and rules. I now get closer into the section 2.2 of the paper there. Rules, I suggest, have this kind of, whenever certain operative facts occur, a certain normative consequence is to follow. That's the logical structure of rules. That's when you try to articulate and make determinate norms of conduct, that's how it comes out. And of course this then can have the kind of entrenchment notion of Fred Schauer, or the protected or exclusionary notion of Joe Raz. Because what happens then is you face a situation, as Tom says, you look only, does OF exist? And if so, you dish out NC or conform to NC, whatever that may be, without looking at the surrounding circumstances. Or without letting your look at the surrounding circumstances affect what you actually do in the capacity of judge or whatever. That's, of course, if you take the rule in a very strong sense. Fred and I have, I think, probably the same idea, although I naturally claimed in the paper that I was slightly different and better. But I will find out in the course of this whether I'm different but wrong, or the same and unoriginal. But right.
Either is okay.
This idea that okay, you've got this formula, somebody's made up the formula, but the next question is what's it to do with it? What's the person in charge to do with it? And you have at least these three possibilities, I suggest. The idea that this is absolute force, absolute practical force, absolute bindingness. That is to say, in no circumstance shall the official be moved by anything other than the finding of fact, OF or not OF. And the further, Fred makes this point very forcefully, the further down ladders of discretion you go, ladders of decision-making you go, the nearer you get to the first-order decision point, the more likely you are to say, we don't want you guys thinking. We want you guys just to decide. If there are problems, send them up the line, and we'll get somebody else with more time, more leisure, more opportunity to reflect, to study the problem. But you guys just do it, bang, 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 and that will be more efficient, more effective, and everybody will know where they are. And also, frankly, you will not give too much discretion to somebody whom you might not think would be very good at exercising it. Maybe wrongly, but that's how you might think. Or there could be strict, rules of strict application, where you say, okay, this formulation is to achieve certain objectives, certain values, and so on. Ordinarily, you just apply it. But if somebody comes forward and says, look, this is rather a special case, there's a particular problem here, you are entitled to override it. But then you need to have some way of specifying just how special the case must be and all that kind of thing. Finally, though I'm not sure if it's a rule of thumb or what it is, I think you can genuinely have rules of purely discretionary application, and you still have a rule, because what you say to people is. But there's a lot of things to be weighed up here. Often it will be rather difficult and obscure. And in the situation where it's difficult or obscure, you can't weigh it up very clearly, then apply the rule. But try if you can to do it as a decision of principle. I used to wonder what people meant when they said equitable remedies are discretionary. So I used to read all these cases, and it doesn't look very discretionary to me. But I think that's what that idea means, that there may be rules of thumb about applying equitable remedies, but the court is never supposed to do so without reflecting upon what the whole balance of advantage and fairness is. So we have different practical force that you can ascribe to rules. And this is not to do with the logic of rules, it's to do with the practical structure of institutions. Just by the way, in this context, number 11 here, I want to talk about the interpretation of rule-making and judicial law-making and interpretation. It's interesting. Tom's version of positivism says judges shouldn't make law. But old-style positivism, descriptive positivism, says judges do in fact make law. All legal orders comprise some balance between rules laid down by the formal legislator and rules laid down by the formal adjudicator deciding cases. Bentham thought this was a very bad thing. It was all judge and co and corrupt and sinister interest and all that kind of stuff. Austin said, well, no, Mr. Bentham uses rather strong language about this. You can't do without judge-made law, and actually what we should wish for is judges who make the law more articulate and more clearly, more openly, and who give some account of what they're doing. Rather like some of the aspects of the realism dispute in the early part of this century. It's interesting, it's the not positivists who say that judicial interpretation is non-innovative. The Dworkin theory, and which many people find implausible on this very ground, says however radical the jump that the court appears to have made is, if they made it right, they didn't make law. The successful decisions are not law-making decisions. The ones that turn out to have been law-making will be winnowed out as the law works itself pure. So there's an interesting, the question of analysis, description, interpretation applies in a fascinating way here on the issue of just what counts as going beyond interpretation, working out the true sense of the thing into actual law making. And I suspect myself that there's too much of an either-or built into that question. But if you do look realistically at number 12 at lawmaking under the modern separation of powers in almost all jurisdictions, and this applies as much to France, where the French really invented a civil code that was supposed to be just exactly like what Tom says. Here are the rules. Then it's Article 4 and 5 of the Civil Code, isn't it? One article says, any judge who declines to decide a case on the pretense that there is no law will be punished. So there's a very strong completeness norm there. But then the other norm, which says, the other article says, any judge who pronounces a decision by way of a general or regulatory provision shall be punished. So the code is complete. And you have to discover what it says. You mustn't make new law. And it still is the case that a judgment in civil law in France is to be quashed as badly motivated, unmotivated in law, if the only ground offered for it is a precedent. All judgments in civil law courts in France must be by reference to an article of the code or one of its underlying principles. Never by reference to, or certainly never by sole reference to, the precedents. And the result, of course, is that precedents are a kind of secret industry in France, but it is a real and important one nevertheless. In all systems, however you interpret the separation of powers, that you get inevitably the kind of Stufenbasing. However determinately the legislator tries to enact the law, the real world is yet more complex than even the most complex piece of drafting. And somebody must concretize the norm for the context of decision. So always, as Kelson says, and surely right, the act of decision is also an act of norm creation. The only issue is whether the norm thus created has general application or only once-off application. And our kind of doctrine, the common law idea, is that it's better that the thing be done publicly, openly, and accepted as at least a defeasible norm for the future, a norm of strict but not absolute binding force, especially first order decisions are very easily reversed. And at each level up, they're harder to reverse, but they never become, not since the House of Lords in 1966, absolutely binding. So the process of lawmaking is a collaborative process. And of course, it's not just the legislature, it's also the executive. Everywhere, most projets de loi, most proposals for law emerge from the executive, but they don't get going unless the legislature buys them. And then thereafter, the implementation is often partly a matter of regulation making by the executive, and always some element of the concretization, determinatio by the courts. So we have to take a view of the legal system that it works that way, and the issue would be what is the practical force under ethical positivism or any other view of the norms of statute law and the inevitable norms of case decision, which we might or might not decide to admit as case law, depending on our theory of sources of law and aspects of our institutional practice. Well, I think I'm just about through, and certainly just about through the time I've been allowed. We come then to the three elements of interpretative argument. Granted that norms are issued, they do have to be interpreted. The group of people with whom I've worked on this, we come from half civilian, half common law, half North Europe, half South Europe, one side of the Atlantic and the other side of the Atlantic. Quite interesting group that we've looked at this. I mean, you come up with this that almost all systems, maybe banal, can be summarized as having this linguistic, the systemic, and the teleological, deontological elements of interpretative argument. You can give arguments of these kinds for why you want to interpret a norm one way or another way in the legal setting. There may be others as well. Intention doesn't really figure, we found. Intention runs across them all. Intention is sort of a way of putting a gloss on all the trans-categorical, we commonly call it. Now, Tom, in a letter to me, says he thinks that our way of putting that, or my way of putting that, allows in too much in the way of appeal to the general principles and the telos or the sense of rightness and all that kind of thing. Personally, I doubt if you can run interpretational systems without drawing on that, apart from any other reason, because linguistic and systemic arguments can themselves compete with each other and more or less be mutually cancelling. So you have to have some way of tie breaking, and that has to be, I think, in terms of a sense of the underlying justice of the scheme. But it should be the justice of the scheme, not the autonomous norms of the judge in person. So, on this view, you can get it more or less. Different systems will differ in the degree to which they encourage boldness in interpretation, taking the big picture, and so on, and in the ways in which they encourage degrees of openness about it. It's interesting, at the fin de siècle, half of the title of his book, Duncan Kennedy comes up with this celebration, really, of judicial politics and the inevitable clash of ideology and the grand drama of the courtroom, just at the same time as Tom Campbell comes up with ethical positivism. Keep it to a minimum. Can't be done without altogether, but keep it to a minimum. So that this is about a dispute about institutional design. I do think, under 14, that in Tom's version of it, as in the book, there is perhaps too much, for my taste, of eliminate the need for evaluative interpretations by courts. I don't think you can. I think it's better to try and find ways of encouraging, training, supporting a rational and modest interpretive style in the courts, and be open about it rather than design the kinds of indigestibly complex legislation that come out of the attempt to leave nothing for the judges to interpret. And in legal actuality, there's been an ever more ready recognition in the civilian countries that there really has to be case law, and that we should be more open about it and more articulate about how it's done. And the orders the common law world moved in the opposite direction now. This does involve, and here's the little bit of Dworkinianism, putting some value also on system coherence. The whole set of systemic arguments depend on thinking we ought to try and keep our law as a more or less coherent overall order. Now you can come down on this with a kind of hard bent for my response. This is back to Judge and Co. and the sinister interests. Democratic legislators will try to get in sensible reforms, and Judge and Co. will sit on them. Because they will say, we know the coherence of the common law and this doesn't fit with it. I think the answer to this is that it can happen that way, but it doesn't have to. The concept doesn't predetermine this. Because saying that the system must be coherent can mean that you have to rethink a lot of the old law because of some radical and important new measure. This is exactly, for good or ill, what will happen in the UK after enactment of the Human Rights Act, which is currently going through Parliament and domesticating the enforcement of most of the European Convention rights in the UK. And it says all previous legislation, and the common law as well by implication, have now to be interpreted to make sure that they conform with this. And in future, all subsequent legislation should be interpreted with a view to showing its conformity where possible. And all subordinate legislation is to be likewise so interpreted but struck down if not valid. In the meantime, in the Scotland Bill currently before Parliament, the restrictions on power imposed on the new Scottish Parliament are given a benign twist by section 28.8, which says, so far as possible, legislation by this Parliament is to be read so as to be inter-party. So it doesn't follow from the demand for ensuring that the law is overall coherent that you just have a conservative bias built in. I think it depends on the law. Wide-ranging laws with a clear purpose to make major changes affect the landscape around them. Narrower-ranging, more modest reforms are probably better interpreted as fitting into the landscape and therefore being more influenced by it. I don't myself think this is anti-democratic. Democracy does not seem to me to contain conceptually the rule of law. But as a practical matter, you cannot over time sustain democratic order without the rule of law. That gives the possibility of free elections, fair opportunities to put points of view, and lack of intimidation and all that kind of thing. Without the rule of law, that is practically impossible. And I think that the whole idea of sustaining the law as a coherent, intelligible framework is critical to the rule of law. So I'm glad that it doesn't necessarily have the kind of conservative spin that I think Tom fears it has. Finally, last point, the ambiguity of the rule of law. Wouldn't the rule of law work better if we could make unambiguous laws and everybody would know where they are? And doesn't it help, for example, if you read in all the trouble préparatoire and words in Hansard and that kind of thing? I don't myself think so. Isn't it important that people who are accused of anything or have claims made against them have the right to answer the allegations of fact and so forth put against them, test the case, test rigorously the case that the other side puts? Doesn't that then also apply, especially if you take a kind of fact view of the law, to the law as well? I think it's an important aspect of a free-minded citizen that they have the right not only to challenge the government's version of the facts, but the government's version of the law. And that also goes in civil litigation as well. So ambiguity, we must remember, is a resource for defendants and plaintiffs too, as well as sometimes a nuisance, a disfigurement of otherwise well-working legal order. If we want to run polities of free-minded democrats, there is no way of stopping people putting all the arguments they can think of about what the law means, and then you just have to have somebody who listens to the interpretive arguments and tries to weigh up which is all things considered the better, taking an overall view of the point and purpose that they ascribe to the legal system. They often make mistakes, they sometimes make us angry, but there isn't really an alternative, is there?
Thank you.
Okay, questions?
I was wondering if I could return to a point about system coherence.
Yes.
System coherence not necessarily being a conservative value. I think that's true, and I think it might be true in another way as well. And working off of a lovely article that Jerry Possum published in the Law Journal on moral presence of our past, which is a justification for precedent. And in thinking about Mabo, the Mabo decision in Australia, I think this is quite an apt way of thinking about things. And that is that we tend to think of system coherence as being static, occurring within a single time frame where we're just trying to reconcile everything that exists at this particular moment. But isn't that a misunderstanding of system coherence? Isn't system coherence almost necessarily dynamic, involving, one could even claim, a measure of moral learning? Because you never attempt, when attempting to engage in a systemically coherent interpretation, you never really attempt to make coherent everything that's on the table. There's always a whittling that occurs. That's okay. I'm now talking primarily leaving out the complications that are introduced through legislation. We're just dealing with something where there isn't an institutional reference that's required. When one works with a body of precedent, one doesn't just try to reconcile everything. One attempts to decide what's important, what's been proven to be valuable, what's the insight that seems to be most particularly apt, what seems to be, in the end, lying down. And so it has a dynamic element to it as well. And so at best, a process of moral learning, which really is inherent in the casuistic method of the.
Yeah, and I personally, I was saying to somebody after one of the sessions, I said it during it too, in this rather rude way, for which I apologize. I'm uneasy about making too big a difference between statute law and common law as, so to say, different domains. Because most of the really interesting things nowadays are both under. I mean, the sale of goods and company law. Company law above all. Are there any principles in company law? Is this a rational system of corporate regulation and governance? Well, yeah, but because it's both, and over time reasonably well-crafted body of legislation understood in the light of, and also always unfolding body of precedent, and so on. In common law systems, statute becomes common law infested. Good thing too.
I wanted to ask about your list of three: linguistic, systemic, and teleological deontology. That section of the paper. One thing you said was when the first two norms, linguistic and systemic, run out, then one must appeal to the underlying justice of the scheme. So you have to turn to the teleological, deontological, and therefore it's unavoidable. I just want to know if you think there's any role for something that Tom mentioned at one point in his book, namely the common moral beliefs of the people of the society. If a judge views himself or herself like a lawyer trying to serve a client, and the client is the people, lawyers often make decisions in cases that go a certain way rather than another way because they know that's what the client wants, even though that's not what they want. And if a judge views himself or herself that way, then they might say, at the point that the linguistic and systemic run out, I shouldn't be asking, do I think this is just? I should be asking, would most people in my society today think this is just? Because those are the ones I'm serving. Now that might also run out, and then eventually you've got to get to teleological and deontological anyway. But I wanted to ask if you think there's any role for judges enforcing the common moral beliefs of their society, even when the judges think those are wrong.
Yes, I think that's one of the most interesting and important questions, and is it where the heart of the dispute between Dworkin and Devlin and the thing from Hart and Devlin. And to some extent, Dworkin said it different. It's not shocking that Devlin thinks community morality counts. What is shocking is what he thinks counts as community morality, which is a nice way of putting it. I mean, there might be an awful lot of prejudice around about people of some religious persuasion or race or sexual orientation, whatever it might be. Now, it's not necessary for judges to try and reform the baser prejudices of their fellow human beings, but it's equally not their position to pander to them. It's a very difficult question. I think I prefer the argument which says something along the lines of impute this not to an ideal, rational legislator, legislating in the context of the community as it now is, acknowledging the state of affairs, but trying to come to a fair resolution of the thing in the light of the whole context. Now, if you take Brown against Board of Education, it probably is true, or it might well be true for all I know, that community opinion in Topeka, Kansas at that time, and certainly points further south, was rooted opposed to desegregating the schools.
But not in the country as a whole.
And it's not clear, Senator, that desegregation legislation would have passed through the Congress at that time. Walter Weirach, Florida, has a fascinating story. He just qualified in law just in 1945 and was one of the few people there who was legally qualified and untainted by the past. So he very young became a Staatsanwalt in I think, Frankfurt. And he had to take, or help taking decisions about the validity of marriages between black American soldiers and white German women who had fallen in love with each other in the course of the occupation. And according to the laws of the home states, miscegenation was still illegal. And according to, so the US military authorities were embarrassed and said, look, you guys just decided according to German law. We won't say a dick about it. Unfortunately, the German law applies the law of the domicile of the marrying spouse. So the German judges found, having just come out of this, found themselves this awful, embarrassing dilemma. They had realized, the German society had come to recognize, all those who were still now in office anyway, come to the realization we must never go down that road again. In no circumstances must we engage in these things which have disfigured our society so appallingly for the last 13 years. Now they found they're having to apply American law. So they didn't. but I think the American authorities were very embarrassed by it. So that was part of the growing recognition in the United States that things, you couldn't have it both ways. But I don't think myself that had necessarily, I don't know. The interesting sociological question, how far had that percolated through to the general consciousness of the citizens of the United States? And I think it might be better for people to say, well, the main ideas of our society are ideas about equality and about non-discrimination and due process. We now discover that what we thought were separate but equal always works as unequal. And therefore, because of a new appreciation of the facts of the matter, the proper understanding of the law is that it does prohibit this. Now, who can say? I mean, Lino Graglia and others argue that it would have changed by legislation quite soon thereafter anyway, and it would be more effectively changed by legislation than by the judicial intervention, which was so much resented in so many parts of the country. So it's a long answer, but I think that judges have to try and figure out what is enlightened legislative opinion, legislative public opinion, like it's phrased, within the community, not just what I, for my part, would like. I don't think it's effectively done, as it were, simply by studying opinion polls or things of that kind. In that sense, forming a view of what the community's morality is important, and it should be both a reasonable view and a genuinely imputable view. So I don't know if we agree on that. It's a difficult and interesting point.
No, I think I agree. And certainly the judge should use the enlightened community's views as much as possible. But that's always so slippery to figure out. That at times, sure, you don't want to have to appeal to opinion polls, but on something like capital punishment, if you want to know whether it's cruel or not, you have a pretty good idea of what most people in society think. And for a judge at that point to say, look, the linguistic and systemic have run out, I've got to make a decision here, I'm going to go, I think capital punishment's wrong, when he or she knows that 80% or 70% or whatever of the population believe that it's not wrong, and it's passing in state after state after state. Seems questionable. I'm not sure whether I might not do it anyway if I was a judge, because I think it is wrong. But it does seem like a usurpation of power.
And the other thing, set aside yes, that's right. It is interesting that European courts now decline to extradite for capitally punishable offences to the United States because they owe to their citizens the obligation under the European Convention that they shall not be subjected to inhuman or degrading treatment. And they interpret subjection to the capital punishment in the form in which it's carried out in the contemporary United States as inhuman or degrading or both treatment. I think I do too. But the issue is, what does what you think affect what you should do in the capacity of a judge?
Neil, I was struck by your comments and your metaphors about the examples of aircraft getting on and queuing. And I'm sure that your unequivocal statement that the queuing and processes of getting onto aircraft do help, always help. I wonder, though, if it does depend on the nature of the individual. I speak here from experience. I remember some years ago getting onto a plane here in Australia, holding my boarding card, and I got to my allotted seat, found somebody in it, and rather self-righteously having checked the number above her and the number on my card, rather self-confidently told her that perhaps we had a confusion. She fished out hers was 23G, mine was 23G. So I thought, wonderful, this is a dispute that has to be resolved. The plane was late at this stage. The steward came down and helped me.
Flight attendant.
And she looked at it. Unfortunately, the sort of bizarre part of this was she was also crutches, so it made it very upsetting.
The possessor of the other G23.
No, the actual
The flight attendant.
yes, which was amazing. This is Graham. This is yeah, sorry. So we looked at this. She then went off. She obviously was a problem. Went off to the pilot. Did some demonstrating. The pilot came back, and I really admired her style. The lady was very flustered with the one at 23G sitting there in situ, and she first turned to her and said, "Madam, that is your seat. 23G is correct." I said, "I'm waiting to see what's going to happen to me." She turned to me and said, "And sir, your seat is 23G also." But then she grabbed me, pushed me down to the porthole, pointed out and said, "But your plane is that one." Now, my question follows, I think, from Walter, and that is that I agree with you. Judges do make law in the sense that I heard you describe it, and therefore there is an evaluative dimension to what they do, and that's a necessary dimension. The question then, I suppose, becomes how do you limit or at least make accountable that function in some democratic way or whatever other indicia you should use. And I was interested by your comment on the first day that you said that you had run a judge's school, or you run some courses in in Scotland and for the Bill of Rights, in the forthcoming Bill of Rights, and it is that point that I wanted to ask. Do you think that in a common law country, with a Bill of Rights coming in with that civilian dimension to it, that will make a qualitative difference, or do you think that your trans-categorical descriptions, the linguistic, systemic, and teleological, will cover that, and that really the only difference will be just a greater emphasis on the teleological for a while, because there's not the systemic and the linguistic skills within somewhere like the United Kingdom? and of course we would learn from that as well.
Yeah. I wonder, yes, as I remarked on the other day too, the European Convention is markedly more detailed and concrete than many other of the genre. And to that extent, I don't suppose that judges in the UK ought to be very particularly more embarrassed at figuring out what it means than other legislation of constitutional import and significance. It's also to be hoped, I suppose, that it will relatively, quite often be tried on by council. It's to be hoped that it will be relatively rarely successful on the grounds that we suppose the Parliament has been legislating away for the last 30 years with an eye to the fact that it has international obligations of this kind. And indeed, we've done quite a lot of law amending in the light of adverse decisions in Strasbourg. So there's that bit of it, plus the fact that this is not itself a raw new piece of enactment. This is legislation with a big aura of interpretive glosses already around it from the European Human Rights Court. It will be important, but particularly important, I think, for council, particularly, I suppose, in fields like criminal law and administrative law, to get up to speed, to be aware of what things that they should be trying out on behalf of clients. Yeah, it's the kind of thing that judges will need to think carefully about. Will it require them to have radically new techniques, or to apply their existing techniques to a new domain? Bit of both, but I think that the existing techniques will work perfectly well over this material once people become familiar with it.
So we made an extracurricular statement as to how they might approach this.
Well, Lord Hope Craighead and Lord Cooper-Saunders and Lord Roger of Earlsferry have all three recently, in my hearing in Edinburgh, made remarks about it and how it's going to make life more difficult and it will increase. The Lord President says, well, that's fine, we're very game to do this, but you need to give us more judges because it's going to take up more judge time and it will otherwise slow down things. So the usual immediate appeal for more money has been forthcoming from the judiciary. But I think that is not so much because judges feel, oh help, we won't manage this, but rather, oh help, dealing with this will add a further twist of complexity to much litigation. It will take longer time, and at least for a while, there will be, as it were, vexatious try-ons until the thing settles down. I think also the judges are interested and excited and trying to find out more about it. Yeah.
I can just a point of queue management. We've got about just under 25 minutes.
I'm talking too long as always.
Well, I was going to say there's a...
Why don't everybody say something and I'll just shut up?
There's currently a list of 9, but of course next session is on the same topic, so perhaps rather than worrying about being too judicious, the people just being patient and bear in mind they might get shoved over to the next session. So, yeah.
I was very interested by the whole discussion, actually, particularly the end, but I want to ask you a question about the first portion, which I found fascinating, but I'd like to ask a little bit more about, what's McCormick really up to, in the following way. Clearly, we work on these theories for a reason. It's not simply, we've been assigned to the jurisprudence faculty. It's our job to, produce stuff. We think this particular theory will help do something. Now, I think I have a sense of what you're working on, but I might be wrong, and I'd like you to clarify it. But I guess the thought I had in mind is, if I look at what Austin is doing, if I look at the first few lectures in the context of the larger work on jurisprudence, if I look at what Hobbes is doing in his theory of law, in the context of his larger political philosophy, I have a very good sense of the sort of political and theoretical project of which it is a part. My sense was that both of